In just 1 second. All right, everyone, just give me 1 moment. I'm signing some documents that have just come through. All right. Bill Davidson, are you here or still in a breakout room? Okay.
Judge, I think he's still in the breakout room.
All right, thank you. James Toshi, is your client on Zoom yet?
Yes, ma'am, she is. She is identified as Leonardo's iPhone, and I see her right there.
All right. Have you been sworn in?
Have I been what?
Sworn in.
Yes, I have. Yes, I have.
All right, well, just give us a moment.
Tochi, Judge, do I have a minute to speak to Tochi in a breakout room?
Sure. I'll send, James, I'll send you to breakout room number 1.
Okay.
All right, Greg Demarais.
Yes, Judge. I just need to make sure Clifford signed his paper. I signed it over lunch.
Okay. Clifford, have you signed your paperwork?
No, ma'am.
Okay, so I'll send you to breakout room number 3, Greg.
Thank you, Judge.
You're welcome. And Clifford, if you could go to 3.
And Judge, inmate Benya hasn't signed his paperwork either. So whenever.
Mr. Pena, who is your attorney?
I don't even know.
It's Kyle.
All right. Well, as soon as Cal comes back, you'll need to sign your paperwork.
Yes, ma'am.
I show that Kyle signed it.
Okay. Well, as soon as Cal zooms back on the Zoom screen, we'll send you to a breakout room with him and he will go over paperwork with you and we'll get that signed.
Yes, ma'am.
All right, are you all ready on Miss Vargas?
Yes, Judge, I am.
All right, and Abel Dominguez, who do you have? You're on mute.
I apologize, Judge. I have April Sanchez. I spoke with her already. I've spoken with the DA. We had an issue arise in that she is 7 months pregnant and needed to figure out if safety or one other inpatient can take her that far along.
Okay, so I'm sending your client to number 1. Rebecca, if you could go to number 1. And Abel, I'll send you to number 1 and we'll figure out that issue.
Okay, thank you, Judge.
And Meredith.
And Meredith was also in that one.
Yes, Meredith. And actually, I'm gonna move your client to number 4.
Okay, Judge, that's fine.
You all can discuss it. Marcus, if you can share your video.
Is this me, Judge?
Oh, no, it wasn't shown at first for some reason.
Oh, no, what case? I don't know if this is one of mine.
Oh, this is Brenda Vargas Carbajal.
I was dealing with Mr. Nisbet. I don't know who's going to handle the plea.
Yeah, sorry, it was from a couple weeks ago. Yes,
Oh, okay. Is it you or is it not you?
I can handle it. I did the paperwork.
Miss Brenda Vargas Carbajal, you need to pay attention to the screen.
Yes,
And you
ma'am.
need to unmute. And is that vehicle moving?
No, it's the people moving.
All right. Court is calling 2020 CR 10196, State of Texas versus Brenda Vargas Carbajal. Can I have parties announced for the record for the state,
Marcus Sanders?
for the defense?
James Tochi for Ms. Carbajal, Judge.
And are you Miss Carbajal?
Yes, ma'am.
We're proceeding by video. Any objections from the state?
No objection.
Any objections from the defense?
None, Judge.
Ms. Carbajal, I'm showing you what's entitled defendant's consent to appear by video. Did you review that with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Is this an application for deferred adjudication?
Yes, it is, Judge.
All right, we have a slight problem because the application that I have that she has signed, it's just an application for community supervision.
Oh, shoot.
So if that can be redone, because I want the record to be clean.
That's fine, Judge. I clearly did not see that.
All right, no problem. Oh, we're here till 5.
I'll send it right over.
Thank you, Norma.
All right, thanks. And so what I'll do is I'll put you in a breakout room with your client.
All right, should not take long, Judge.
Sure, I'll send you out of breakout room number 5. All right, to the clerks, you should be receiving paperwork on Clifford. All right, are you ready to proceed on Clifford?
We are, Your Honor.
All right, who's the prosecutor for Clifford?
Hunter was helping me.
Okay. All right, the court is calling 2020 CR 6129, State of Texas versus John Clifford. Can I have parties announced for the record for the state,
Hunter Morris.
for the defense?
Greg Desmarais.
All right, and are you Mr. Clifford?
Yes, ma'am.
We're proceeding by video. Any objections from the state?
None, Judge.
Any objections from the defense?
None from the defense, Your Honor.
Mr. Clifford, did you sign a document entitled Defendant's Consent to Appear by Video? And did you review that document with your attorney?
Yes, ma'am, I did.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am, I did.
Are you the same John D. Clifford who was placed on deferred adjudication? Thank you. And 2020 CR 6129 for the offense of possession of a controlled substance, penalty group 1 less than 1 gram, on January 26, 2021 for a period of 2 years. Is that you?
That is me, ma'am.
All right, state.
On or about the 12th day of February 2021 in Bexar County, Texas, the defendant John D. Clifford did then and there illegally use a controlled substance, namely meth or amphetamines, in violation of condition number 2.
How do you plead to that? True or not true?
True, ma'am.
State.
On or about the 9th day of April 2021 in Bexar County, Texas, the defendant John D. Clifford then and there failed to comply with the requirements of felony veterans court in violation of condition 21.
How do you plead to that? True or not true?
That's true, Your
I
Honor.
got you. I got you, John.
The state would waive and abandon the remaining allegations.
Any objections to the state's waivers?
No, Your Honor.
All right, Mr. Clifford, did you understand by pleading true to violation of conditions 2 and 21, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility, and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of conditions 2 and 21?
Yes, ma'am.
Court will find 2 and 21 true. Is there an agreement?
There is not, Judge.
All right. State, what are you requesting?
For this court to deny the MTR and have the defendant submit to a McMyoff evaluation, treatment if qualified and eligible, if not, IOP, referral back to the Veterans Drug Court.
All right, defense, what are you requesting? And Mr. Clifford, I'm going to mute you for a moment because there's a lot of noise coming from your side. Defense, what are you requesting?
Judge, in essence, the same thing. We want you to deny the MTR, but we'd like you to follow. There was 2 TAP recommendations, and the one we're asking for is IOP, intensive outpatient treatment. He is willing to comply with the Veterans Court. He did not have his DD Form 214 at the time. Now he does, so he'll be able to follow that. He does have 2 jobs, he said, waiting when he gets out. He does take care of his mom. He lives with his mom. So he got put on probation, I believe, in December. He's been in jail for 6 weeks, Your Honor. So we would ask you to, instead of doing the inpatient, we'd ask for outpatient.
All right. So first off, does Veteran Treatment Court want him back?
And we're not opposed to him not doing Veterans Court.
No, I mean, do they want him back? Because I thought I heard y'all say that something about considering him, placing him back in Veterans Treatment Court.
I was talking with Rebecca, Judge, and it seems like they were never able to complete the paperwork. There was no indication that he was no longer welcome.
And my
Just that they
understanding,
were held up.
Okay.
and they were held up because my understanding in talking with John is he needed his DD Form 214. He didn't have that. I think he took a little bit longer to get it, but my understanding is he now has it.
All right. So was he ever, I guess, did they ever even interview him?
No, Judge. They tried calling him and there was a lot of unanswered phone calls.
He's willing, Judge.
All right. So here's the thing, Mr. Clifford, it appears to the court that, yes, you have a drug problem because you're not able to get forms that Veterans Treatment Court is asking for, but you continue to use drugs. So how often are you using drugs?
I haven't used drugs in about 4 months, man.
No, that's not my question. How often do you use drugs? I'm sure at the Bexar County Jail, sometimes people use drugs while they're at the jail, they make wine or whatever. But you haven't been using drugs since you've been in custody. Before you were taken in custody, how often were you using drugs?
I hadn't used them in a while, ma'am. I've been sober for a couple months.
Here's the thing. These violations are in February. Now, the violations that the state hasn't asked you to plead, I'm not going to, I'm sorry, could you? All right. The violations that are in the motion to revoke, the ones that the state didn't go on, I'm not going to accept those as true because you haven't played through them. However, what I'm seeing here is marijuana, alcohol, opiates, meth. That's in February. And in March, I have you not taking a UA and then not reporting in March, not registering for the theft program, not showing proof of employment. And when was he arrested or taken into custody? Does anyone know?
He says he's been in there 6 weeks. So was it the end of May, maybe beginning of June? Does that seem right, John?
Yes, sir.
So what that means, Mr. Clifford, is nobody's heard from you since, we know for sure nobody's heard from you since March.
Ma'am, I've been reporting to, I was on another probation.
I'm talking about for this court. I'm not talking about other courts. I'm talking about what have you done for this court?
You're right, ma'am. I apologize.
No. I'm just trying to figure out what have you done for this court on this probation? Because I'm trying to figure out what to do with you.
I thought the theft program, I thought I had 2 years to do it. The veteran sport, I had to get the DD 214, which I now have. And I've just been trying to work, save money. And I paid up all the fees I could.
Well, see, let me just tell you, it's not so much 100% about fees. It's more about you maintaining your sobriety, which you have not been doing, and staying in contact with probation for this probation, which you have not been doing.
I know I can comply with it, ma'am.
Well, I mean, here's the thing. I know what you're saying, and you're saying what you think I want to hear, right? But what I'm telling you right now, you've shown me that you can't comply with it. So again, I'm trying to figure out what to do. Now, both the state and the defense are telling me that they don't want you to be revoked. Okay, I'll go along with that, with not revoking you, although I'm gonna give you a choice when it comes to revocation. But I'm trying to figure out what to do with you.
I'd like to just get back to work, ma'am. I mean, I have 2 jobs waiting.
Well, here's the thing, Mr. Clifford. You can't write your own program. If you could, we wouldn't be here. Like if you have a drug problem, which to me, it's clear you do. You know, it doesn't make you a bad person. It doesn't make you a good person. It's just a fact, right? If you could stop using drugs on your own, then we wouldn't have this positive UAs for marijuana, alcohol, opiates, and meth. So you can't write your own program, right? Whatever problem people have, if they could have solved it on their own, we wouldn't be here. So when you can't write your own program, that means that somebody else has to write it. So I'm going to give you a choice. One, I can grant the motion, revoke you. What's his criminal history? Does anyone know that? Do you have a criminal history, Mr. Clifford?
No, not much, ma'am.
Well, see, it's either yes or no.
He has a DWI that we're going to plead to, Judge, that came out of this or before this case. Prior to that, though, Hunter, do you see anything else? He did receive 2 years deferred on this, so.
No prior felony convictions, Judge, but I can see in county.
Okay. So here's the thing. I can do something with you and continue on probation, or I can grant the motion, revoke you, and I'll give you 6 months.
I'd like to hear what the probation is, ma'am.
Well, see, here's the thing. Either way, you're going to end up in custody, because either you're going to get custody till you get transferred to ISF, or either you're going to get in custody because you're going to be transferred to the state jail facility. But you need treatment. And I will refer you back to felony drug court if that's what you want, but you're going to remain in custody until felony drug court accepts you. If felony drug court doesn't accept you, then you'll go to ISF. Because the problem is you have a drug problem, and it's not just the marijuana. It's not just meth, it's opiates as well. And if you really think about it, I'm not trying to punish you. I'm just trying to give you options and give you choices, but there are consequences to your choices. If you think about it, anybody who's on probation who know that they could go up to 2 years to the state jail facility, and one of their choices is, if I smoke marijuana, I could have 2 years of my life taken away. Somebody who's not addicted or in the throes of their addiction would say, I'm not risking 2 years. Same thing with opiates. If somebody said, hey, if I take this opiate, I could go to state jail for 2 years. I'm not giving up my life for 2 years. Same thing with meth. But you made choices, and your choices were marijuana, meth, and opiates. So I'm giving you a choice. I can revoke you, give you 6 months. You're done. You can write your own program, which I think you're going to have a difficult time doing, but there are treatments that you can take advantage of, or you can be continued. I'll refer you back to felony Veterans Treatment Court or ISF.
They had offered me lifetime recovery. I don't know if that's still an option.
Now, here's the thing. You're still trying to write your own program. You're not writing your program. I'm going to write your program today. So those are your choices.
I'll take the 6 months, ma'am.
Did you want to discuss that with your attorney?
Your Honor, we discussed his options at length. I think Mr. Clifford is aware that it was either inpatient or maybe get revoked. And so he is understanding. Am I right, John?
Yes, sir.
And Judge and Greg, just to correct an earlier statement, he does have a prior state jail conviction. It was a sentence following deferred for insatif. So it would be a second state jail.
Okay. Thank you.
All right. So are you requesting that you be revoked, Mr. Clifford?
I guess that's what I'm requesting, ma'am.
Well, I mean, let's not guess. It's either yes or no. I'm
Yes,
not
ma'am.
forcing you to do anything. If you want to be revoked, I will revoke you.
Yes, ma'am.
All right. I'm going to grant the motion. Find you guilty. Are you waiving your right to appeal?
I'd rather not, ma'am. No.
Oh. Greg, you want to speak to your client about that?
Your Honor, I can. I think he's just keeping his options open, but obviously,
Okay. I'll send you to a breakout room with
Thanks,
your
Jim.
client. I'll send you to breakout room number 1. Thanks. All right, let me see. Hi, John. You're always in Alaska.
Got to keep it fresh, Judge.
All right. John, we were actually working on John Clifford. But
Yes, ma'am.
I think he was trying to get documentation. He didn't have certain documentation, but now I think he's choosing to go to prison.
Okay. Yes, ma'am.
But I appreciate you zooming in very quickly. It's like
No.
the bat is sitting there.
No problem at all, ma'am. And just to clarify, we did receive some documentation of it. However, he missed an assessment. We couldn't find him, and now we are where we are today. But if he ever needs help, he can reach out to us.
Okay, awesome. Thank you so much.
Thank you, ma'am.
And Your Honor, Kyle Ernst is here and I put him in a breakout room, so inmate Pena will need to go back to breakout room 7.
All right, Mr. Pena, if you'll go to breakout room number 7, please.
Judge, may I approach?
Who wants to approach?
This is Abel Dominguez.
Yes.
I'm here again on April Sanchez. I spoke with the DA and probation. We are still, as of right now, at a loss of what to do with her because of her being 7 months pregnant. Probation cannot think of a facility that will take her. I would kindly ask the court if we can recall this for about a week or two, give me a chance to look in to see if any other defense attorneys have had this issue before, and maybe they can help out and point me in a direction of where to go.
And Your Honor, just so you know, Lifetime will not take her. And so I was asking Abel if he can find a place that works. I would be amendable, but that might take longer than this afternoon. So.
Oh, well, just one moment. I'm going to find a place for her right now.
Thank you, Judge.
Sure, no problem. Are there drug issues involved?
Yes.
What is the alleged drug of choice? Hello?
Let me see, Your Honor. I don't believe there's a drug allegation on the MTR, Your Honor.
All right, then just give me 1 second. I'll get right back to you, okay?
All right, Your Honor.
Judge, she was ordered outpatient in drug court, but didn't do it. So I don't have, you see what I'm saying? So I don't know for sure what the issue is, but we knew that was part of the conditions.
Okay, all right. I just sent out an email. I should have something back for you guys in just a minute. All right, we're going to go back on the record on 2020 CR 6129.
Your Honor,
All
I
right.
spoke with my client and he is waiving his right of appeal.
All right. Mr. Clifford, are you waiving your right to appeal?
Yes, ma'am.
And are you asking that the court revoke?
I'm sorry, the first one is gonna be the admonishment.
Excuse me, stop. Stop. We are in a hearing. Where's that coming from, Brenna?
I think Owens, but they muted.
Okay. Okay, I'm like, where's this noise coming from? People, it's a Wednesday. Let's not make it into a Monday. All right. So, Mr. Clifford, are you asking the court to revoke you?
Yes, ma'am.
All right, the court will revoke you then and find you guilty. The court will sentence you to 6 months in the state jail facility, give you credit for any time served. Are you waiving your right to appeal?
Yes, ma'am.
All right, is there anything else from either side with regards to sentencing?
Nothing from the state judge.
Nothing from the defense, Your Honor.
Mr. Clifford, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney and did you understand it?
Yes, ma'am.
All right. Because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, with that, we'll go off the record. Mr. Clifford, while you were in the breakout room, a representative from Veterans Treatment Court came in. They said, of course, when you're released, you're always available to talk with them. and they're available to help you. When you're released, there are so many places that are free: NA meetings, AA meetings, all different types of treatment facilities that will work with you. But they can't work with you if you don't reach out to them and if you don't take advantage of what they're offering. I wish you the best, Mr. Clifford.
You have a great day, man. Thank you.
All right, you too. Thank you. Norma, can you let them know that L4 can go back?
Yes, ma'am.
All right, bye, Greg.
Thank you, Judge. Thank you, Hunter. Thank you,
You're
ma'am.
welcome. All right, I do, just one second. I'm going to forward this to you, Meredith.
Thank you.
And if you could make sure it goes to Defense Counsel. And then I'm going to take up James Toshi's case.
Judge,
And if you could, I'm sorry, just one second. And Meredith, if you could also send that to Rebecca as well. And I'm going to send Rebecca and Meredith back in the breakout room with probation so that you all can talk with Abel Dominguez about this.
Okay, thank you, Judge.
All right, and Abel, I'm just trying to find you. Were you previously in a breakout room or did you sign out?
I accidentally signed out by accident.
All right, I'm going to send you to number 2.
Right, thank you,
Greg,
Judge.
did you need anything else with us? All right, thanks. Tell Stephanie I said hi.
I will, Judge. No, ma'am. I was just chatting up Hunter, just making sure we were good. But I will tell Stephanie, she's at a coach's clinic right now, so I'm manning the house. So it's time to go get Chipotle.
Okay, all righty.
See you, Judge. Thank you.
All right, bye-bye. All right, who's the prosecutor on Ms. Carbajal?
I'll step in, Judge.
All right, thank you, Hunter. And then Bill Davidson?
Yes, Your Honor.
On your client, Mr. Owens, my understanding from Norma Ferguson is that he was interviewed. So we're just waiting to get the report back. Norma, when are we recalling Mr. Owens?
The 16th, Judge.
All right, Mr. Owens, we're going to come back on the 16th. I'm being told that the report will be ready by then, okay?
Thank you, Your Honor.
All right, thank you. You're excused.
Thank you.
Your Honor, it's Lisa Boyd. When you have a minute, can you tell me where I am in the lineup?
Right now, we're doing a hearing. Okay. All right. The court is calling 2020 CR 10196. We're back on the record. Ms. Carbajal, I'm showing you a document entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney and did you understand it? You're on mute.
Oh, yes, ma'am.
And did you electronically sign it?
Yes, ma'am.
Counsel, have you received all the discovery in this case and did you review it with your client?
Yes, I have, Judge, and yes, I did.
All right, the court will find that the state is in compliance with discovery. Ms. Carbajal, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
There's pleading to lesser included offense of driving while intoxicated.
Any objections?
None, Judge.
Ms. Carbajal, I'm going to show you what's entitled Court's Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, ma'am.
All right, off the record for a moment. Norma, can you let them know that Mr. Owens, 17C, can go back, please?
Yes, ma'am.
All right, we are back on the record. Did you understand what you're charged with is driving while intoxicated as a Class B misdemeanor? The range of punishment is up to 180 days in the Bexar County Jail and up to a $2,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could sentence you to up to 180 days in the Bexar County Jail and up to a $2,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Carbajal, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, I am.
Are you a U.S. citizen?
No.
She's not a citizen?
No, I have a case with immigration. We're fixing all my paperwork for a visa, a U visa.
Okay, just give me one moment.
Judge, I'm not sure I was aware of that.
Okay, so
Can we have some time, Judge? I'm very, very sorry about this. I thought this was an issue that she's been in my office a few times. Can we have a reset for at least 2 weeks? I'm so sorry.
oh no, you know what, Mr. Toshi, and we're off the record. You know what? It's a Wednesday. Sometimes Wednesdays can turn into Mondays, but it's still enjoyable as long as you smile, right?
Okay. I appreciate you saying that.
Yeah, you know what I find if you smile, it softens the blow.
Good.
For example, Brenda, look, it's raining outside and you don't have your umbrella, you're gonna get wet. But watch this. It's raining outside. You're probably going to get wet without an umbrella. Don't you feel better the second way? So there you go. All right. So
Judge, I'll communicate with Norma. I anticipate we are still going to push forward. However, let me tighten this up a little bit.
all right. So how much time do you need?
I would say no more than 2 weeks, Judge. No more.
All right, Norma, can you recall Ms. Carbajal for 2 weeks, please?
Yes, ma'am. I can recall her for either July 28th, Judge, or it will be August 2nd.
All righty, July 28th or August 2nd.
Real quick. August 2nd is a better day for me.
All right, we will be back on August 2nd.
Thank you very much, Judge.
All right, you're welcome. See you then.
Yes, ma'am. Brenda, you can leave. I'm going to call you right now.
Okay, thank you.
Okay. All right, the next person up is Lisa Voigt.
All right, my phone was overheating, so I was trying to figure out where I needed to next.
No problem. Would you like to talk to your client about his positive UA?
Oh, yes, I would.
All right, Mr. Dennis, I'm going to send you to a breakout room. Courtroom, if you can go to number 4, Mr. Dennis, your attorney will be there to speak to you about your positive UA that you told the court would not be positive because you had not used for 2 years.
Yes, Your Honor.
Oh, they'll take you there. All right, let me see. Nathaniel Navy.
Good afternoon, Judge.
I told you yesterday,
That was Monday.
Was that Monday, Brenna?
Yeah, 2 days ago.
Okay, wow. It's because he's here every day. Okay, so we have you for Dakota Gettler,
Yes.
3rd violation report, and Tyrone Shepherd.
Yes.
So do you want to start with Mr. Gettler first?
Sure, Judge. He was here this morning, so he's been waiting.
All right, do you want to speak to the state about this issue?
If I could speak to the state, yes, Judge.
Okay.
And it's a CTD case.
Okay. All right, I'll send you to breakout room number 1.
Thank you.
And Ms. Sanchez, just give us a moment. We're gonna find out what we can do to help you.
Thank you, ma'am.
Luis Martinez.
Hello, Judge.
Hi, who do you have?
Judge, I need to approach on Ramsey Gonzalez. That's the motioner to withdraw plea that we talked about on Monday, and I told the court we'd have some issues to discuss with regards to his bond.
Okay. Have you conferred with the prosecutor?
Judge, I have.
Mhm.
I conferred with Kelsey. I've conferred with Audrey. They don't have a position.
Surely they would have a position. Audrey, what's your position?
Yes, Judge. Well, Mr.
I mean,
Martinez.
surely you guys care. What's going on? What's the position?
Yes, Judge. Speaking with Kelsey Leslie, she had left me a note that they were going to remain silent as to the bond reinstatement, and I think that's due to some issues that the complainant's mother was having with the defendant's girlfriend, complicated issue. But I think that's what it has to deal with. So that note is correct that we are to remain silent as to the issue of the bond reinstatement.
And Judge, I'm not asking for reinstatement. I'm asking for the court to set the bond. He's been held without bond right now. I did provide the court a letter from his doctor detailing his medical conditions. So he does have some medical conditions that we would hope would necessitate him getting bonds so we can get back out and get those addressed.
Okay, let me send you to a breakout room with Norma Ferguson because I don't see your client on the screen. So just give
No,
me one second.
he's not on the screen, Judge. I'm trying to approach just to ask about bond.
Okay, because I would need to speak to him. If I'm setting his bond, and I will set him a bond,
Okay.
but I need to speak to him face to face.
Okay, then we'll need to get this reset for us to get Mr. Gonzalez here from the jail.
Okay, I'm going to send you to breakout room number 3, and Miss Ferguson, I'll send her to number 3 so you all can confer on what dates you want to come back. And
Thank
I'm
you,
here
Judge.
from 9 to 5 every day.
No, I'm in the office from 8 to 5 every day.
All righty. Are we ready on your client, Miss Voigt?
Yes, Your Honor.
All right, who was the prosecutor on Miss Voigt's client?
Marcus Sanders.
All right, Marcus, are you there, or is there another prosecutor there? All right, we'll see about getting a prosecutor. Just give me a second. As soon as we have a prosecutor, we'll take that up. All right, Rebecca and Meredith on Sanchez, do we have a plan?
So, yes, Judge, I was calling essentially on Abel's behalf, I guess, answering questions with this woman, and provided all the information I have to her. I've provided the contact information to Abel, but they are going to have to, someone is going to have to reach out again to set up like a questionnaire and an evaluation to make sure she is eligible.
All right, where is Abel?
His phone died.
Okay, it's Monday on a Wednesday.
Because there's a bunch of questions that I'm not going to know the answer to, like that, you know, what is her drug of choice, things like that. But anyway, we've started the process, Judge.
Okay, all right, Ms. Sanchez, your attorney's cell phone died, so they're not here. This is what's going to end up happening. I'm going to recall this case. I'm going to recall it for tomorrow. And your attorney is going to be here tomorrow. And we're going to find out what's the status of who needs to be contacted. You're going to need to be very honest with them about whatever drug issues you may have, because we're trying to get help for you, help for your child. I don't know if you've ever seen a child born addicted to drugs, but it's not a pleasant sight. Because the way adults go through withdrawals, babies go through withdrawals. And the only difference is babies don't know why they're going through withdrawals. And it's very painful to see. You understand?
Yes,
so
ma'am.
you're gonna remain in custody. We're gonna get you the drug treatment that you obviously need. Norma, can we recall this for tomorrow or either Friday? You may need to recall it for Friday. Norma?
Yes, ma'am.
Can we recall April Sanchez for Friday?
Yes, ma'am.
All right, we're gonna recall you for Friday, Ms. Sanchez, and we're trying to work. I'm gonna need you to be patient.
Yes, ma'am.
We're gonna try to work to get you the help that you and your baby need. So we're gonna come back on July 16th.
Okay. Thank you, ma'am.
All right, thank you. You're welcome. Norma, you can let them know that L21 can go back.
Okay, Judge.
All right, thank you. All right, Lisa Boyd, thank you for your patience. Is there a prosecutor available for Ms. Boyd?
I'm available, Judge. What case is this?
Oh, thank you, Hunter. It's Mr. Dennis. We were waiting for Mr. Dennis to have his UA. And Mr. Dennis did have his UA. He told me it would be negative. And of course it wasn't, it was positive. So we'll address that issue. And let me just make this note, Ms. Boyd. All right, we are back on the record. And cause number 2019 CR 12726, State of Texas versus Jeremy Christian Dennis. Going to have parties announced for the record for the state.
Hunter Morris.
For the defense.
Lisa Voigt for defense.
All right, and are you Mr. Dennis?
Yes, Your Honor.
All right, this is a continuation of the hearing from this morning. Mr. Dennis informed the court that he would be negative for drugs, and he is positive. Mr. Dennis, you are under oath. So you want to explain to the court why you're positive for drugs if the last time you did drugs was 2 years ago? Because that's what you told the court.
Yes, Your Honor. Can I start off by saying that I apologize? I mean, I'm real nervous.
No, let me stop you right there.
Yes, ma'am.
Nervousness doesn't equal to someone being dishonest. So you want to explain to the court, because you said that you haven't used drugs for 2 years. I don't know. And of course, you know, there's a learning curve for everybody, but I don't know of any controlled substance that stays in your system for 2 years.
No, you're right. That's the truth. I mean, I lied. I did. I smoked marijuana over the weekend. I did. I didn't think that you would piss test me, honestly. I didn't think that you would even ask.
Well, your attorney told you that I always ask about drug testing.
Yeah, she did. You're right. There's no excuse. I mean, I did it. I'm sorry. I mean, I can't take it back now. I mean, I'm willing to, whatever you want to offer as like help. I mean, I'm willing to take whatever you feel is positive, whatever you feel is right, honestly. I mean, I'm in this situation.
You want to ask some questions of your client?
Sure. Mr. Dennis, at this point, are you asking the judge to approve your application for deferred adjudication?
Yes, ma'am, I am.
And are you willing to engage in any drug rehabilitation programs the judge feels are appropriate for you?
Yes, whatever she feels is right.
Okay, and why is it that you're asking for probation?
I mean, I'm young. I I have a good job. You know, I did run into some problems a couple of years back, and I've learned from those mistakes that that's not the life that I want. You know, I have a good, strong family. Like right now, they're all watching me on YouTube, and I'm pretty sure they're all disappointed in me. I'm really disappointed. And I mean, I don't want to go to jail. I don't think that'll help me really. I mean, I've always worked hard. I have had problems in the past where I do slip and I fall, but I always tend to get up, like pick myself back up and move on with life. But sometimes, you know, I do have those slips still. I mean, I had a difficult childhood. My mom, I know you said earlier that my mom wasn't a part of my life, but she recently came back since I've been out on bond. And that's difficult too, because she still has a heroin problem. She still has a big drug problem. And I don't like talking to her because she's mostly all the time, I can't understand her. I mean, she's my mom. I always love her, but I mean, sometimes you got to cut off the people that aren't good for you. And that's what I've done. And I've just been working, paying my bills, paying my monitor, paying my I still got a bond I still pay. I mean, it's kind of hard on me, but I mean, I can do it. I mean, I'm strong enough to where I can do it. I make good money. I mean, I work hard. I work really hard. It kind of sucks that I have a set schedule on the monitor, which I really wish that I didn't, because I'd be able to work a lot more hours, make a lot more money. But I mean, hey, it is what I did is where I'm at now, and all I can do is move forward.
Okay, I'll pass the witness, Your Honor.
All right, any questions from the state?
My understanding, Judge, is that the plea was to kept him silent.
Yes.
No questions.
All right, Rebecca, for some reason, my computer had, thank you, Rebecca.
It just said.
All right, thank you. I don't know where it just disappeared on me. So, Mr. Dennis, here's the court's question. At what point do you believe the decisions you make are your own decisions, and it's not because of your childhood? When does it become your fault?
The moment I commit a crime, the moment I do the things that I do. I mean, it's all my fault. Everything's my fault.
So why are you bringing up your mom as an excuse? And that's what it is. It's an excuse for your actions.
You're right. You're 100% right. And I don't know, I just felt like it would be something that, I mean, I just had to get off my chest. I know I'm an adult already. I'm barely gonna turn 30 on the 19th, and you know, it's time for a change. I mean, it is. It's time for a change, and it's time for me to realize that.
You've been on probation, and you were on probation for a theft case, and you were revoked.
Yes.
Why didn't you successfully complete that?
Why did I successfully?
No, why did you not? Because you didn't. You got sent to prison.
Yeah, it was they were trying to reinstate me, but I chose to take the state jail time instead, which honestly, at that time, I needed that. I was not in the right place. I was pretty bad on ice, on methamphetamine. It's pretty bad. And I feel like my best option would be go to jail and just get away from that whole little town that I was at, because that town got, I mean, it did a number on me. And I mean, I was pretty bad. I went to 130 pounds at 6'2", and that's, even my whole family was disappointed. I didn't think I was going to get as much time as they gave me, but you know, I was a lot younger. I wasn't ready for a change back then, I guess. I mean, that's the honest truth. I wasn't ready. I was still young, and I don't know what I was thinking. I mean, I look back to this day, and I'm still shocked at like the decisions I made back then compared to like now, how I make them, how I work, and how I try to do my best every day. You know, I wake up every day, go a day at a time, just trying to do the right thing, honestly.
Okay, the state is silent, but I'm trying to understand the cap of 10 years.
Yes, Judge?
Yes, I'm just trying to understand that. Is there something about the defendant's criminal history that the court is unaware of? Does anyone know?
Judge, it looks like there is a case being taken into consideration. It's a second degree.
Okay. Okay. All right, just everyone give me a moment. All right, on that other case that's pending, that's being taken in consideration, who is the complainant? Does anyone know?
I'll find out for you, Judge.
Thank you.
Derek Wilson.
All right, who is Derek Wilson, Mr. Dennis?
He was a neighbor at the apartment complex. Where me and my wife had lived. I guess it was 2 years ago. We were drinking and we happened to get into an altercation.
Well, no, I'm just asking you who he is.
Yeah.
So
he was
is that complainant aware of what's happening here today, Mr. Morris? Do you know? Is there anything in notes?
Let me ask, Judge.
All right, thank you.
Hi, Judge.
Yes.
Based on information gathered, I do not believe Mr. Wilson is aware of the sentencing at the moment.
All right, and what's his full name?
Derek Wilson, Derek DERICK. Wilson, WILSON.
All right, this is what the court is going to do. The court is going to deny your application for deferred adjudication. The court is going to find you guilty. The court will sentence you to 8 years in prison, suspended and probated for 6 years. There's to be no contact with Stephanie Roel, ROEL, no contact with Derek Wilson. Taking consideration 2019 CR 12721, County Court Cause number 645795. Defendant is to remain on GPS for 6 months. Random field visits. Two times per month. Proof of employment within 15 days. No employment as a home health care provider or any employment involving minors. Parenting classes. CPS compliance if applicable. Intensive outpatient treatment with probation. Random UAs or the patch. Regular Zoom reporting or in person. Rebecca, is there anything else that he needs?
No, ma'am.
Mr. Dennis, is there anything else that you need in order to be successful?
No, ma'am, I mean, it's. if you feel like that- if you
Your
feel
Honor.
like there's- Go
Yes.
ahead, Lisa.
Yeah, if I may speak, I know that he's concerned about Stephanie. They have a common law marriage. She's been in constant contact with me throughout this case. And they've been separated because of the orders that are in place. But it was their intention to get back together as a couple and continue their life together.
Yeah, well, you have a choice to make, Mr. Dennis. You can either get back together with her and potentially go to prison for 8 years, or either you can not get back to her and maybe not go to prison. It's completely up to you. But that no contact order is in place for a reason. You understand?
Yes, Your Honor.
And maybe you two are just not good together. It's up to you. I mean, if you want to go to prison, I will send you to prison.
No,
and then,
no, I don't.
And
I
then
do
once
not.
you get out of prison, you can see whomever you want to see.
No.
But there's a reason there's a no contact order between you two. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
Because this is a felony conviction, and also because you're on probation, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Mr. Dennis, you have some choices that you need to make in your life. I'm going to tell you what I tell many people who appear before me. Everybody, at least, well, I wouldn't say everybody, but a lot of people have had horrible childhoods, right? At some point in time, your decisions are 100% your own. You can't be blaming your mother. You can't be blaming how you were raised, because you're an adult and you're choosing to make the decisions that you make. Do you understand?
Yes, completely.
And the reason for that no contact order, you know why. So let me give you another piece of advice. To get control of your anger issues, get an orchid. They're like $12. Keep it alive for a year. Let it bloom. And if it does, then maybe you should be in a relationship. If not, then you should keep working on that orchid, okay?
Okay, Your Honor.
All right, I'm going to send you to a breakout room to speak with probation. I'm going to send you to breakout room number 1.
Okay.
Courtroom, if you go to number 1, so he could go over his conditions. Ms. Boyd, you can go to 1, or either you're excused.
Thank you, Your
You're welcome. All right, anyone ready?
Your Honor, this is April Dominguez. I'm back from April Sanchez. I had to get to my office because my phone died.
All right, we're going to recall your case for Friday.
Okay,
So
for
if
Friday?
you can get in, yes, if you can get in touch with the persons or the person or persons, because they're going to need some more information from your client.
Okay, Your Honor. Thank you. I'll do that. Thank you.
All right, and if you get in touch with them and they're able to Zoom in on Friday, they can come in on Friday and speak with her and you in the breakout room.
Okay, thank you, Your Honor.
All right, thank you.
Your Honor,
Yes.
this is Leslie Sakai. I'm sorry I was late. Can I confer with one of the ADAs about the MTR for Ms. Rebello?
Is it criminal trial division?
Yes, it is, Judge.
All right, I'll send you number 2.
Thank you.
And let me see, Nathaniel Navy, you're back on Dakota.
Yes, Judge, and I'm ready to proceed.
All right, is there agreement or no?
Well, so the state's position is they won't file any motion to increase his bond as long as he provides proof of an alcohol or an AA sponsor.
Okay, let me see, who's the prosecutor you were speaking with?
Mr.
All right, let me see you all both in breakout room number 3, please. All right, Mr. Gettler.
Yes, ma'am, I'm here.
All right, you're gonna have to get a sponsor. You're gonna have to get a sponsor by the 26th. If you do not have a sponsor by July 26th, we're gonna have issues. I know usually it takes people a while to get sponsors because it needs to be someone that you feel comfortable with sharing with and connecting with, but you obviously have a drinking problem. And so you're gonna need to do that. You understand?
Yes, ma'am. Can I have the sponsor, like, I actually have a personal friend that has went completely sober and has offered, but they're not here locally in San Antonio. Is that okay?
That's someone that you'll have to discuss that
Okay.
with pretrial services.
Yes, ma'am. So I'll just go through my
But what I
office.
will tell you is, from my experience, and when I say my experience, not my experience and using, because honestly, I don't drink alcohol because I think it tastes nasty. No offense to people who want to drink alcohol, but maybe it's not best to have a sponsor who's a friend, because you want someone who's going to be open and honest with you. Not saying your friend is not going to be open and honest with you, but when you have a friend who's a sponsor, then it's sort of like, do I want to lose Dakota as a friend, or how's this going to be? So it's probably best that you get a sponsor who's not a personal friend.
Yes, ma'am. Totally understand.
All right, if there's nothing else for Dakota Gettler, I'll let him be excused. Nathaniel, do you need to speak with him at all?
No, Judge, thank you.
All right, Mr. Gettler, you're excused. You need to take care of that.
Yes, ma'am. Thank you.
You're welcome. All right, who else do you have with us, Nathaniel?
I have Tyrone Shepard, Judge. This is coming back from the hearing that we had on Friday, where you were going to determine what kind of a bond you were going to set, if you were going to set one.
Okay. And have you had a chance to confer?
I have not.
All right, is there anyone available to confer with Mr. Navy on Tyrone Shepard?
And for the sake of continuity, Ms. McIntyre was the one that's been handling this case.
And what were we exactly conferring on?
It's related to a bond.
No, I remember. We weren't on the same page, and so that's why.
Yeah, we don't need to, I guess.
I mean, I'm happy to confer with him again.
All right. Communication is key, everyone. So I'll send you to breakout room number 4, Nathaniel.
Thank you.
You're welcome.
Excuse me, Judge.
Yes.
On Mr. Dennis, he wanted to know if GPS, if he's still going to be able to be to work.
Yes.
Okay.
Yes, he's allowed to work while on GPS.
Okay, thank you, Your Honor. It's gonna be the same times, right? From 8 to 7 like they've been?
Yes.
Okay, thank you.
All right, you're welcome.
God bless you.
Oh, thank you. God bless you too. Be better, do better, know better.
Oh, yes, ma'am, I will. Thank you. You have a wonderful Wednesday.
All right, you too. Okay, let me see who we have left. So we have Valencia Robello, who I don't see on the Zoom screen. And then we have Hagerling. Who is his attorney? Who's your attorney, Mr. Hagerling?
Nathaniel.
Oh, Nathaniel Navy? Okay. All right, and then Mr. Pena, we just need your attorney here.
So how are you doing, Judge?
Oh, I'm doing okay. It's Wednesday. I mean, you've got to be happy when it's Wednesday.
That's true. 2 more days.
Yeah, and welcome to the 187.
Thank you. Thank you. Thank you. They asked me Monday if I'll sit in, and I said, sure.
Oh,
So
well, thank you. Yes, they tell us Joe Ray has MAG duty.
yes. Yep. I think it's his first one too. We were partners in County Court 8 with Judge Roman for a long time, and then we both got promoted together. So
Okay.
I was like, yeah, I'll cover for you.
Oh, well, congratulations.
Thank you.
Yes. All right, guys, sorry about that. So are we in any type of agreement with Mr. Shepherd or no?
No, Your Honor. This was an extension of the hearing on Friday where the state asked for his bond. Should this, Your Honor, set a bond be doubled from the original amount? And Mr. Navy was actually asking for a substantially less amount than the original amount.
And that's true, Judge. Or if you would consider reinstating his bond if he got the GPS, and he would be amenable to. I know he was on GPS, but if he had it reinstalled, I know that he had that zone for his apartment complex. Even if you were going to make that zone be to where it was just the building, he's perfectly willing to comply with any other condition
Okay,
like that.
But this is the one where he actually removed the GPS, is that correct?
Correct, Judge.
Correct, Judge, but he didn't actually, or at least there's no evidence that he actually went anywhere. He didn't contact the complaining witness. When he was arrested for that violation, he was just arrested in the same apartment that he was supposed to be in, according to his GPS conditions.
Well, and Judge, I don't know if you'll remember from the hearing, but there were 5 days that were unaccounted for. So we actually don't know where he was for 5 days. So I don't know that that's necessarily true.
Okay, all right, we're gonna go on the record. We're back on the record in 2021 CR 4086, State of Texas versus Tyrone Shepherd. We're having a hearing to reinstate bond or set bond. And this is a continuation of that hearing. So are both parties ready?
Yes, Judge.
Your Honor.
Okay. All right, and this hearing appeared to have began on July 9th. State's Exhibit number 1 was admitted without objection. And State's Exhibit number 2 was admitted without objection. The court had a chance to review State's Exhibits 1 and State's Exhibit number 2, and the court heard and has read the motion from defense counsel. Is there any other argument from either side?
Nothing.
Honor,
I'm sorry. Go ahead.
Go ahead, Nate.
All right, defense, it's your motion. You can go first.
I was just going to say nothing additional, Judge, but I don't know if you'd like for me to kind of outline my argument from Friday, just so that it's a little bit more fresh.
Sure.
Okay. Basically, when this case started out, Judge, or when Mr. Shepherd was on bond, the state filed a motion to amend his bond based not on any violations or anything like that, but just due to the alleged nature of the underlying facts of the case. Mr. Shepherd actually agreed to have the GPS device installed. He didn't fight that. He gave up his firearms, which was another condition that the state requested. He did that without incident. The DA's office investigator that picked those up stated he did that willingly, complied, was very polite with them. And then Mr. Shepherd did remove his device, but he, in my conversations with him, it was just due to the discomfort of it when he would exercise and things like that. He said it would hurt with his circulation and other things like that. And he, at least to my knowledge, Judge, and from the evidence that the state provided, he really didn't go anywhere that was far away from his apartment complex. Even the violations, if you'll recall at the hearing from Friday, where he was outside of that bubble where he was supposed to be when there was violations on the GPS, he was just barely right outside that zone where he was supposed to be in. It was the pretrial services officer agreed to that. And it looked like there was some sort of creek or trail that's right behind his apartment complex where that was. I know that Mr. Shepard he likes to take walks just to assist with his mental health. I think it helps him. And so it's clear to me that he wasn't taking off the GPS to actually go anywhere. He didn't get in contact with the complaining witness. There's no evidence that he tried to contact the complaining witness. And I would just argue that the purpose of the GPS device is so that you don't flee and so that you don't contact the complaining witness in the case. And there's no evidence that he fled. Like I said, he was arrested at his apartment. He was just cooking right there at his apartment when he was arrested. So there's no evidence that, that he's a flight risk or he took it off to go anywhere or, make contact with any specific person or anything like that. I know that the court was probably not going to be in agreement with that, but his family is on Zoom today. They're very supportive of him. However, they do live in Georgia, Judge. They would be willing to take care of him or and provide him with any assistance he needed if he was able to bond out. I know that his apartment complex is most likely, or they're in the process of evicting him just because they found out, or to my knowledge, it was because they're evicting him because they found out about this charge. And because of that, I think that violates the condition of his lease. If somebody's charged with that, they have the discretion to kick him out. So I believe that somebody from Georgia would probably be coming down to help him find a place if he needs to, if he is able to bond out. So he does have the support of his family. I would just ask, I think that he'll comply with his GPS device, Judge, and not make that, that mistake, obviously, of taking off the device. Obviously, that's a huge deal, but he didn't do anything in order to get in touch with anybody or flee. So I would just ask that you reinstate his bond or have his new bond be at $20,000, just because he's not going to be, I don't believe he's going to be able to post the bond himself. He'd have to have the help of his family, and they already posted the amount for a $60,000 bond. And so any amount in addition to that, even if we're keeping it at that same amount, they've already posted that amount, Judge. That's why I'm not asking for the same bond, and I'm asking for a lower bond, because that's already been done before, and it would drain some substantial resources from them.
All right, stay.
Your Honor, just to kind of summarize what we said on Friday as well, the state has a different perspective on this defendant and this situation. Not only is the GPS device there to protect the victim in the current offense, but it's also a matter of protecting the community at large. And with a case like this, a violent offense, someone who struggles with mental health, who, when not in compliance with that, has the tendency to become violent, we're also looking at the safety of the community. Mr. Shepard removed his device, so he violated his bond condition. He was unaccounted for 5 days. We don't know where he went in those 5 days. He was also outside of his zone. His zone was substantially too large, in the state's opinion, to keep the community safe. We're asking that the court, based on his violations of his bond, actually raise the amount beyond the 60. From our perspective, we don't believe it makes sense to essentially reward someone for violating their bond conditions on a violent offense by giving them a substantially lower bond. So that's what the state is asking for. And Your Honor, it was not part of the hearing, but the state, and I won't get into the facts because it has not been investigated yet, but the state just became aware this morning that a warrant is being walked on an additional case on this particular defendant. So no matter what we decide today, there's going to be further bond issues in the future.
Mr. Navy, are you aware about this warrant?
Only, I mean, just from hearing that from the state when we went to the breakout room, Judge, I don't know any of the facts of that case. I think the state I'm not going to speak for them, but I don't think that they're very clear on the facts of that case. So I would say that's something that you shouldn't consider for purposes of this hearing, just because there's no evidence before you. I think we should just consider what the evidence was from the hearing on Friday. Because I can't defend against that when I don't even know what the allegation is, if there's any merit to it or not, Judge.
Okay. Well, what I can tell, if there's nothing else, no further argument for either side, I'm not inclined and I'm not going to reduce his bond. At the end of the day, Mr. Shepherd, and we say remove, but I'm assuming he cut off his GPS because there isn't, you unbuckle it. So is that what happened? He cut it off? Is that correct?
I'm not aware of the circumstances of how it was removed. I just know that it was.
Okay. So I'm not going to reduce his bond. So he had a previous bond of 60,000. The state, you are asking for 120. Defense, knowing that the court is not going to reduce his bond, the state is asking for 120. What would you be asking for? Are you still going to stand on reducing it?
I would stand on reducing it, Judge. I think I would frame it a little bit differently, since we're not reducing his bond. This is going to be an additional bond to something he's already posted. So no matter what it is, it's going to be more than 60. I wouldn't say I'm not asking for his original bond to be less. He's already posted that. And now whatever amount he would have to post is just in addition to that. So that's just why I would argue for that lower amount, because when you add that up, it's, even if you made it 20,000, that would be a total of 80, which is still higher than what it originally was. That's just my perspective, Judge.
All right, the court is going to set his bond at $80,000. All other previous conditions will be given, with the only exception, it's going to be full house arrest. And if the defendant is released from custody and he has a medical appointment, then he's going to have to receive pre-approval for those appointments. But it's going to be $80,000 and it is going to be full GPS.
And Your Honor, is there a way to clarify with the GPS and the department? Because I was unaware until this hearing how they do that zone.
Oh no, on this full GPS, and he is going to remain inside whatever location.
So that includes like not being able to go to the mail center and things like that on the other side of the complex?
No, he's going to have to remain inside the location. And if he, Mr. Navy, if he shows the court that he is able to follow the court's orders, then of course, the court is always willing to reconsider to give him some more freedom. But now we're back to where we were before, which is full GPS.
Okay, thank you, Judge.
You're welcome. Do you need to speak with your client?
I have one other matter, Judge, so I'll probably just set up an appointment with him either tomorrow or Friday.
All right. Norman, can you let them know that Mr. Shepherd, 14F, can go back? And Mr. Shepherd, when the court gives rules, you've got to follow those rules.
Yes,
if there's an issue with a rule, then you still need to follow the rule, address it with your attorney, and the court will set it on the docket.
Yes, ma'am.
Sure. All right, they're going to take you back, Mr. Shepherd.
Yes, ma'am.
Thank you.
I already called them, Judge.
All right, thank you. All right, Mr. Navy, who else do you have?
I think that he should be here. Is Kevin Hagerling here from
Yes.
jail? He is?
Yes.
Okay. Could I confer with the family violence prosecutor?
Okay.
Marcus, can you check a chat?
Okay, Nathaniel, I'll send you to breakout room number 3. All right, Leslie Sekwanowicz, what is happening with your client?
I know she's here.
Yes.
And I was conferring in one of the breakout rooms, and then with ADA Meredith McIntyre, and then Mr. Hunter Morris came in, and I was waiting, and so I'm not sure where we are.
Who do you need to confer with?
That's the part I'm not clear about.
His client, he needs to confer with his client.
Thank you.
Okay, well,
All right.
well, I wasn't
Leslie, if
clear
you
with it.
go
There
to
was-
number one,
Well,
Valencia Robello, if you'll go to one, please.
Okay, well, I wasn't clear whether never mind.
I called for you. I called for you, Les. I didn't see it.
Yeah, that's fine. That's fine.
Sorry, Hunter, I thought I'd already given him an offer.
All right, and Norma, we need the attorney for Mr. Pena.
I'll give him a call right now, Judge.
Thank you.
Judge, can I see you in a breakout room?
Yes. Breakout room number 2.
Hey, Robert, I sent you a chat. If you could look at it.
Okay, yeah. Let me take a look. I'll message you back right now.
Thank you.
Huh?
Rebecca, could you go to breakout room number 2, please? And Leslie, are you ready on your client? Leslie Sakwanowicz.
Sorry, Judge, I was on mute. I need to go back and see my client. She told me to check on something. I'll check with the clerk so I can go back and talk to her now, please.
All right. If you'll go back to breakout room number 1, she's in number 1.
Thank you.
You're welcome. Cal Ernst, your client, Mr. Pena, is here. I'll send you to a breakout room to speak with the state. Send you to breakout room number 4.
I think paperwork should be done. Do you have it on those, Judge?
I don't have any, let me see. To the clerks, do you have the file on Pena with the paperwork?
I have bits and pieces on both cases, so I actually need to, I can go in there with them and see what's missing.
Okay.
Well, yeah.
All right, I'm gonna send you out to breakout room number 4. So Cal, if you'll go to 4, and Mr. Pena, let me see what breakout room you're in. If you'll go to 4, please. And then to the clerk, if you'll go to 4, please. Mr. Pena, I need you to go to the breakout room. Do you see it popping up on your screen to go to a breakout room?
It says breakout room on the bottom.
Yes, click on that and go to breakout room number 5, okay?
Yes, ma'am.
Sorry, Judge, I had to log back in. Is it possible to send me to room 4?
Oh, no problem.
Thank you.
And I've actually had to move them to room 5. Are you with Hagerling and Nathaniel Navy, or are you with Ernst?
No, I'm with Ernst.
Okay, all right. I'll send you to number 5.
Hunter, are you there?
Yes, I am here.
Can I talk to you about Ms. Rebello?
All right, I'll send you to breakout room number 2.
Thank you.
You're welcome. Nathaniel, you ready on Mr. Hagerling?
Yes, Judge, if you'll just give me a couple minutes, I just got something that the state emailed me and I think emailed to the court as well.
Okay.
Just to review that.
That's correct, Judge. I did send to the court and to defense counsel the police report on the latest offense. The defendant is accused of, as well as the defendant's criminal history.
All right, and Mr. Navy, the court will not review that until it's entered into evidence.
Okay, Judge. But if you could just give me a moment just to read it real quick.
Oh, no, take your time.
Thank you.
Judge, can you send me to a breakout room with Rebecca, please?
Yes. Let me see. I'll send you all to breakout room number 4.
Judge, can I go to a breakout room with my client before we take this up?
Yes.
Thanks.
I'll send you all to breakout room number 6. Mr. Hagerling, I'm going to send you to number 6. All right, Leslie Sekwanowicz, you're back. And I guess he's not back.
Judge, I believe he just needs to talk to his client now.
Okay, all right, thank you. Mr. Pena, you're back.
And Judge, thank you for being so patient the past couple days. It's been quite a couple days for me.
No problem. Everybody should have some patience in their pocket and sprinkle it around as needed. But you are welcome.
I appreciate it.
Yes, Mr. Sakanowicz.
Can I go into room number 1? I think that's where my client was.
Oh, okay, we will send you to number 1. And are the parties ready on Mr. Pena?
Yes, Your Honor, we are ready.
Judge.
All right, yes. Who's the prosecutor on this?
I am, Your Honor.
Okay.
And Your Honor, before we get started, I just want to make a note. Mr. Pena does not read English, but I did thoroughly go over all the plea documents with him and explain everything to him.
Do we need an interpreter?
No, we don't need an interpreter. No, he speaks English fine. He just can't read.
Okay. All right, the court is calling 2021 CR 5886 and 2021 5887, State of Texas versus Renee Pena. Could I have parties announced for the record for the state?
McIntyre for the state.
For the defense?
Kyle Lawrence for Mr. Pena.
And are you Mr. Renee Pena?
Yes, ma'am.
We're proceeding by video. Any objection from the state?
No, Your Honor.
Any objections from the defense?
No, Your Honor.
Mr. Pena,
Yes,
are
ma'am.
you able to read English?
No.
Okay. Are you able to understand English?
Yes.
And
ma'am.
are you fluent in English?
Yes, ma'am.
All right, my understanding, defense, is that you reviewed all of these documents with your client. Is that correct?
Yes, Your Honor, that is correct.
Do you have any concern that your client did not understand what he was signing?
No, Your Honor, I didn't have any concern. I was very thorough with both cases, going over everything and then explaining everything in the documents.
All right, I'm trying to think of a nice way to say this. Mr. Pena, is your first language English or is it Spanish?
It's English.
Okay, so is this a situation where Mr. Pena is just unable to read?
Correct, Your Honor.
Okay. All right, Mr. Pena, I'm going to go over all of the documents with you. If there's something you don't understand, just let me know.
Yes, ma'am.
All right, so Mr. Pena, in each of these cause numbers, are you agreeing to appear by video?
No. Yeah.
Oh, no. Okay, so Mr. Pena, you're appearing by video. Is that correct?
Yes, ma'am.
Are you okay with appearing by video?
Yes, ma'am.
All right, and did you sign a document stating that you would be okay with appearing by video?
Yes, ma'am.
Then in each of the cause numbers, the court will find that the defendant has knowingly and voluntarily consented to appear by video. Defense, in each of the cause numbers, did you receive all the discovery and did you review it with your client?
Yes, Your Honor, I did.
Then in each of the cause numbers, the court will find that the state is in compliance with discovery. Mr. Pena, in each of the cause numbers, did your attorney explain to you documents that were entitled True Bill of Indictment?
Yes, ma'am.
Did you understand?
Yes, ma'am.
Counsel, do you waive the reading of the indictment in each of those cause numbers?
Yes, Your Honor, I do.
State in cause number 2021 CR 5886, are you proceeding on the indictment as presented?
No, Your Honor, in 5886, the state is going to waive count 1 as well as the repeat enhancement allegation and proceed on count 2.
Meredith, you kind of trailed off.
I'm sorry, where did I get cut off?
As well as the repeat enhancement allegations.
And then we will proceed on count 2.
Okay, thank you.
All right. Any objections?
No objections, Your Honor.
And state in cause number 2021 CR 5887, are you proceeding on the indictment as presented?
No, Your Honor, in that one, we will waive the repeat enhancement allegation. I believe there's not a count 2 in that one.
Any objections to the state's waivers?
No objections.
Then, Mr. Pena, in each of the cause numbers, did you review documents entitled Court Admonishments with your attorney? Did you understand it and did you electronically sign it in all the appropriate places?
Yes, Your Honor.
In each of the cause numbers, you're charged with possession of a controlled substance, penalty group 1, less than 1 gram. Those are state jail felonies. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
And each of the cause numbers, if you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered into a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
And each of the cause numbers, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into plea bargain agreements in each of these cause numbers?
Yes, ma'am.
Counsel, in each of these cause numbers, has your client been able to provide you with any defenses?
Yes, Your Honor, he has.
And each of the cause numbers, do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor, he does.
And each of the cause numbers, do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor, very much so.
Mr. Pena, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
And each of the cause numbers, has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
And each of the cause numbers, are you satisfied with the way you've been represented?
Yes, ma'am.
And in each of the cause numbers, are you a U.S. citizen?
Yes, ma'am.
In each of the cause numbers, the court will find that the defendant has knowingly and voluntarily waived his right to jury trial. In each of the cause numbers, did you review the page entitled plea bargain?
Yes, ma'am.
In each of the cause numbers, according to the plea bargain agreement, there are no applications for community supervision or deferred adjudication. In each of the cause numbers, the state is requesting that your punishment be assessed at 8 months in the state jail facility. The cases will run concurrent with each other, and the state will take in consideration 2021 CR 4748. Did you understand that to be the plea bargain agreement in
Yes,
each
ma'am.
of the cause numbers?
Yes, ma'am.
Defense, is that the plea bargain agreement in each of the cause numbers?
Meredith,
Yeah, Your Honor, I don't know if it's not on there, but it's supposed to be 18 months.
and that's what I discussed with Mr. Pena.
Okay, I thought I said 18 months state
Oh,
jail.
we
It
thought you said
sounded like
8.
8.
Yeah, it
Sorry,
sounded
we
like
just want to
8.
make
Sorry.
sure.
I was like, all right, whatever, but
I
Oh,
wasn't.
no, I'm so sorry. And Brenna actually wrote 8. I'm sorry.
Oh, that's okay, Your Honor.
18 months. Well, if Mr. Pena, if you heard 8 months, I know you were excited. I'm sorry to take that away from you, but it's 18 months in each of the cause numbers. Did everyone understand that to be the punishment to be assessed in each of these cause numbers? State?
Yes, Judge.
Defense?
yes, Judge.
All right, then in each of the cause numbers, Mr. Pena, did you review a paragraph entitled waiver of appeal, and did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only
Yeah.
items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor, there is not.
Then in cause number 2021 CR 5886 to count 2, how do you plead? Guilty, not guilty, or no contest?
No contest.
And in cause number 2021 CR 5887, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea in those cause numbers.
In both cause numbers, the state asks the court to introduce State's Exhibit 1 and all attachments.
No objections.
Mr. Pena, in each of the cause numbers, did you review documents or have documents read to you that were entitled waiver and consent to stipulation of testimony and stipulations? Did you review those documents?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Then in each of the cause numbers, the court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence State's Exhibits 1 and 2 and State's Exhibits 1 and attachments, and the court will review the same. All right, in each of the cause numbers, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty in each of the cause numbers. Are you proceeding with sentencing?
Yes, ma'am.
Yes, Your Honor.
All right, then in cause number 2021 CR 5886, the court will follow your agreement, sentence you to 18 months in the state jail facility, give you credit for any time served. This will run concurrent with 2021 CR 5887. Court will take in consideration 2021 CR 4748. And in cause number 2021 CR 5887, the court will sentence you to 18 months in the state jail facility, give you credit for any time served. This will run concurrent with 2021 CR 5886. Court will take in consideration 2021 CR 4748. Is there anything from either side with regards to sentencing?
Nothing from the defense, Your Honor.
All right, I'm sorry, State.
I was saying no, Judge.
All right, thank you. Mr. Pena, in each of these cause numbers, did you review documents entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
All right, in each of these cause numbers, because this is a plea bargain agreement, because I call it your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And in each of these cause numbers, because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, we can go off the record. So, Mr. Pena, why are you unable to read? What's going on?
I don't know. I guess I was a hyper kid.
Well, I mean, there are plenty of hyper people, but they read. Here's the thing. If you can't read, you don't know if somebody's saying anything about you, right?
I mean, yeah. Yeah.
You're dependent on the kindness of strangers to read for you.
Yeah.
So while you're at the prison, you need to try to better yourself. Read something.
Yes, ma'am.
You know, and let me explain something. Sometimes people, they feel a certain kind of way because I don't want to read a book that says, you know, see Jack run or whatever, but everybody has to start somewhere with reading. So you may be listening to me and say, whatever, I'm going to do whatever I want to do, but you won't be able to get pretty far if you're not reading. The other thing is I see that you have a drug problem. There are plenty of places that can help you with your drug problem.
Yes, ma'am.
So you look healthy now, but if you don't change your ways, you're going to end up being the guy in the prison who can't read, but people come to for advice. You're going to be like, you're going to look up, you're going to be 80 years old, and people are going to be saying, hey, what happened to that guy Pena? And they're like, oh, he's the grandfather at the prison. If you want to know how to get your laundry done, go to Grandpa Pena. If you don't want that to turn out to be you, you're going to have to change your ways. You understand?
Yes, ma'am.
All right, good luck to you. And what's up with that tattoo with the tongue sticking out?
It's not a tongue.
Okay, is that not a tongue?
No, that's his grill.
Oh, he has a grill. All right, so is it, you didn't get a chance to have them put in gold paint or diamonds on it or something?
No, it's just a regular grill.
Oh, okay. All right, well, was that painful?
Nah.
Okay, well, did anybody write any lettering on that?
What do you mean?
Did anybody write any words on that?
Nah.
All right, see, you can't even let people put words down because you're not sure if they're giving you the correct words. All right, well, good luck to you, Mr. Pena. I hope you have a great rest of your day.
Okay, you too.
Good luck, Mr. Pena. Take
All right.
advantage of whatever they have at the state jail facility.
Okay, thank you.
All right, bye-bye. Norma,
Bye.
can you let them know 17E can go back?
And Your Honor, that's all I have. Feel like I've been with you all day periodically. May I be excused?
Oh, yes, you're excused. Thank you.
Thank you, Judge. See y'all later.
Bye-bye. Leslie Sagwanowicz, are we ready for your client?
Sorry, I forgot to unmute myself. Norma, I sent Norma a chat asking her to send me a waiver for the appeal. And also I think we know what we're gonna do. I need to talk to Hunter one more time about the specifics.
All right, I'll send you to breakout room number 2. And when you come back, Mr. Sagwanowicz, you're gonna need to show your video.
Okay,
Judge,
All right, thank you.
I got terrible hair today.
Judge, I need his email address. I need the.
All right, and we need your email address. That needs to be in the chat box. Norma, I'll send you to the breakout room with him and Hunter. Number 2.
Thank you.
Hunter, can you put me in? Thank you.
Hi, are you ready on Mr. Hagerling?
Yes, Judge, I'm ready.
All right, is there going to be agreement or no?
There's no agreement. I think the state is just going to leave it up to your discretion, Judge.
That's correct, Your Honor.
Okay. Oh, and let me ask everyone, when are we going to hear this motion to revoke?
I don't know, Judge. I don't think it's been set for a date yet.
Okay. All right, well, we'll make sure we get a date before we leave here today.
Okay.
All right, Brenna, are you ready? All right, the court is calling 2019 CR 11098, State of Texas versus Kevin Hagerling. Can I have parties announced for the record for the state?
Yes, Your Honor. Audrey Vasquez for the state.
For the defense?
Nathaniel Navy, Your Honor.
All right, and are you Mr. Hagerling?
Yes, Your Honor.
You're proceeding by video. Any objections from the state?
No objections, Your Honor.
Any
No, Your Honor.
objections from the defense?
No, Your Honor.
All right, Mr. Hagerling, do you have any objections with us proceeding by video?
No, Your Honor.
All right, the defense has filed a motion to set bond. State, have you had a chance to review the motion?
Yes, Your Honor, we have.
All right, state, are you ready to proceed?
Yes, Your Honor.
Defense, are you ready to proceed?
I'm ready, Judge.
All right, defense, it's your motion. You may proceed.
And Judge, just to give you a little bit of background, I guess, on the procedural history, he has this motion to, it's a motion to adjudicate. He was placed on deferred adjudication. He has not been convicted of that offense. He was placed on deferred adjudication. He has an allegation from a case in April of 2021. However, there's been no police reports produced on that case. I haven't seen anything in e-discovery. I don't think the state has anything on there either. And then there are, hold on, sorry. Sorry, Judge. And then he was arrested on the 4th of July for a new allegation. On that case, there's actually 2 cases, but I think that violates it violates double jeopardy because he was arrested. There are two charges. One is strangulation and one is assault with a prior conviction. So I think
Mr. Navy, I'm sorry, someone has just come into the office. Could you give me one moment, please?
No problem, Judge.
Hunter,
Yes.
can you move Leslie and his client into a breakout room to go over paperwork?
Yes, ma'am.
Please, thank you.
It looks like Les and Mr. Bello are both assigned to one, so they just need to join one.
Okay. All right, and Mr. Navy, I'm back.
Okay, Judge. What I was saying is there's one incident that's alleged and law enforcement charged him with strangulation and assault with a previous conviction. And so I think that the state's going to have to elect one of those. They can't go forward on both. But because of that, he has 2 $50,000 bonds on those already. Okay. So I think one of those needs to be dismissed just because they can't proceed on both of those. So right now he's facing $100,000 to get out. That's not even considering his motion to adjudicate. And on his motion to adjudicate, Judge, I would be asking that you set a bond in the amount of $10,000 when you consider how much he has pending on those 2 other cases, one of which we believe should be dismissed. He takes care of his father, who's 70 years old. Obviously, his father's having a little bit more of a difficult time with him in custody. He's a small business owner, Judge. He does remodeling, fencing, some construction, things of that nature. And right now he's actually worried because he's had to leave, because he's been in custody, he's had to leave some clients basically on the hook where he's accepted money from them. And now he's worried that, they might say that he's not or holding up his end of the bargain. But regardless of that issue, he would still like to be out, to be able to work and provide finances for his child, who's very young, that he has with the complaining witness. And I know that the state sent some documents over, which was the new allegations for the case from the 4th of July. I went over that with my client. I'm actually not his attorney on that one, Judge. He would need to hire me on those cases, but he does currently have a different attorney on those. So unfortunately, I can't argue as far as a bond on that. I think that she would have to proceed on any bond motion with those cases, because those are her cases. But my client does deny many of the allegations that's in that motion, or I'm sorry, that's in that police report. He thinks it's very misleading. And there was some things in there that he was just shocked to hear that were being alleged against him. That's why I felt that it was necessary to send over some photographs so you get at least another side of the picture, Judge, which I'd like to offer as defendants exhibits 1 through 3. Those are photographs of bite marks on his arm and scratch marks. And those are photographs that he took shortly after that allegation on April 19th, 2021, just to give you another side of the story. So you're not painted one, just seeing it from one report and have a prejudicial view of my client. And just if you consider all of that, Judge, the massive amount of the bonds that he's already facing, with everything else, I would just ask for a $10,000 bond on his motion to adjudicate.
All right, any objections to defense's exhibits 1, 2, and 3?
No objections, Your Honor.
All right, then defense's exhibits 1, 2, and 3, which are photographs, are admitted into evidence. Any witnesses from the defense or no?
No, Judge.
All right, state.
Thank you, Your Honor. At this time, there is no agreement. At this time, the state is going to oppose the the $10,000 bond, and respectfully ask the court to send something that ensures the safety.
State, do you have any exhibits to offer?
Yes, Your Honor. We do have State's Exhibit 1, which is the titled K. Hagerling Police Report, which is from the July 4th incident. And we have tendered those to defense counsel.
All right, any objections to State's exhibits number 1?
No, Your Honor.
We also have State's Exhibit number 2, which is titled Kevin Gennaro Hagerling, which is the defendant's Bexar County criminal history.
All right, any objections to State's exhibit number 2?
No, Your Honor. I would just like you to keep in mind that many of those are not convictions. I know that it probably looks bad just because you see his name a number of times, but there was also another instance where he was double charged, like he is now, of 2 offenses where they could only proceed on 1. So it's going to look like a lot, but at least a few of those were ones that law enforcement was basically double dipping on.
All right. The court has had a chance to review the State's exhibits 1 and 2 and defense's exhibits 1, 2, and 3. The court will hear argument. Defense, it's your motion. You may proceed first.
Judge, I would just reiterate everything I said. That basically was my argument. He's facing $100,000 worth of bonds. He'd like to be out to help take care of his father, help take care of his baby. He has clients that he's had to leave on the hook. Judge, I would just ask that you set up this amount. Oh yeah, and I forgot to mention, Judge, he's been in contact with a pretrial services officer He's completed a behavioral cognitive class. I'm sorry, not a pretrial services officer. Somebody with CPS where he did complete behavioral cognitive class. He's done drug testing. He's had no positives at all. Those have all been clean. And he's been in total compliance with CPS.
All right, state.
Thank you, Your Honor. Kind of to piggyback off of what defense counsel said about this defendant's criminal history. So the original offense, which is the MTR, was picked up November 26, or I'm sorry, was adjudicated on November 26, 2019, and was placed on deferred for 5 years, Judge. He then goes on to pick up an assault family second, assault pregnant person, which defense counsel was stating he was double booked for both of those. He did plead true on a MTR. So that offense date is, let me back up, August 21st, 2020. And it was listed as the number 1 on this current MTR, on the first MTR. He was continued on February 23rd, 2021, extended for 2 years, and the assault of a pregnant person was TIC'd. 2 months later, Judge, he goes on to pick up a continuous family violence. That's the case that the state currently does not have any information on, so I'm not able to tell you if it's the same victim. An MTR is subsequently filed on May 10th, 2021, and a warrant was issued. Then 2 months after that MTR was filed, a second MTR was filed, he picked up the assault, family choking, strangulation second, and the assault family second offense. In Your Honor, the offense that which he is currently facing the MTR, the assault of a pregnant person, and the new July 4th incident is all the same complainant. It is Myrna Alcantara. And so, Judge, since he does have a pattern of reoffending, and not only reoffending, but a pattern of violent reoffending where he is charged with assaulting, choking this woman, the mother of his child, while she was pregnant on one case, which was TIC'd, we just feel that the safety of not only the victim, but of the community is at issue here. And so we respectfully ask the court to set a bond that ensures the safety of the complainant and the community.
All right, what bond amount are you asking for, Ms. Vasquez?
Your Honor, at this point, we're asking for a $50,000 bond, as well as full house arrest, GPS full house arrest.
What was your client's original bond at, Mr. Navy?
I'm sorry, Judge, original bond for, because this is for an MTR where he
Yes,
has.
no, I mean his original bond for this case before he was given probation. I'll look through the file.
I see.
I believe it was at 1,500, which was back in August 2019.
Okay. All right. This is what the court is going to do.
And Judge, before, I just have one more request. I'm sorry to interrupt you.
No problem.
If you were going to do house arrest, or I'm sorry, GPS as a condition of his bond, I would just request, with exceptions, where he would be able to work and still be able to work for his small business and complete those jobs that he has outstanding and pending.
Okay. Court's going to set his bond at $40,000. There's going to be full GPS. We'll take up the issues of his employment as it occurs, Mr. Navy. And
Thank you,
there
Judge.
is to be, you're welcome, there's to be no contact with Myrma, M-I-R-M-A, Alcantara. Mr. Hagerling, I don't know what you don't understand about no contact, but you are not to have any contact. And Norma, can I get a date for Mr. Hagerling's motion to revoke, please?
Yes, ma'am. Give me 1 second.
And do you all know yet, is this going to be contested or not?
I have no idea, Judge, because I believe I haven't even received the police reports for the case, which is the alleged violation.
All right, so Norma, with Mr. Hagerling, let's reset this for 3 weeks. And at the 3-week mark, State, please have tendered to Mr. Navy whatever he needs, and then we're going to give a contested hearing date, or either it's going to be a plea or true.
I know, Judge, it's set at August 3rd.
All right, so we're going to come back on August 3rd. So State, if you can make sure you get with the defense counsel as far as discovery.
Yes, Your Honor.
All right, Mr. Navy, do you need to speak with Mr. Hagerline anymore?
No, Judge.
All right, Norma, can you let them know that 14B can go back?
Yes.
All right. And Mr. Navy, we'll see you tomorrow.
Thank you. You will actually.
Oh, we will. Okay. Leslie Sekwanowicz, are we ready on your client? What is happening with Leslie Sekwanowicz's client?
She signed the notice of appeal already. So I don't know where that paperwork went. or
She's
where
in
it
a
goes.
breakout room. I'm going to close all the rooms and we're going to have her come into this room.
Okay.
And Judge,
Regardless of what's happening, we're leaving at, we're closing down at 5. Yes, Hunter.
as a heads up, this case, I believe it's going to be a plea of true and a sentence. The defense is going to ask for a delay in sentencing due to some familial circumstances, I believe. So would the court prefer that the plea be entered now and sentencing be reset?
Yes.
Okay.
All right, Miss Valencia Robello, I need you to show your video, please. And you need to unmute.
It looks like they're both in 7.
Oh, no, I shut down all the rooms.
Oh, okay.
All right, the court is calling 2020 CR 2117, State of Texas versus Valencia Robello. Can I have the parties announced for the record for the state?
Morris.
For the defense. For the defense, Leslie Sekwanowicz.
Yes, I'm here, Judge. The defense.
You're not
We're ready, Judge.
answering.
Sorry.
For the
I'm here,
defense.
Judge. I'm present.
State your name on the record for the defense. Am I
Leslie Sakanowicz for the defense, Judge.
All right, and are you Valencia Robello?
Yes, ma'am.
We're proceeding by video. Any objections from the state?
None, Judge.
Any objections from the defense?
No, ma'am.
No objection, Your Honor.
Ms. Robello, did you sign a document entitled Defendant's Consent to Appear by Video? And did you understand it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Motion to Revoke Community Supervision. Did you review that document with your attorney and did you understand it?
Yes, ma'am.
Are you the same Valencia Marie Robello who was placed on community supervision in 2020 CR 2117 for the offense of theft of property, $500 to $1,500 on October 8, 2020 for a term of 2 years? Is that you?
Yes, ma'am.
State.
On or about the 8th day of October 2020 in Bexar County, Texas, the defendant, Valencia Marie Robello, did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and/or duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True.
The state would waive and abandon the remaining allegation.
Any objections to state's waivers?
I know, Your Honor. There's no objections to state waiver.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, sentence you to 1 year in the Bexar County Jail and up to a $500 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, ma'am.
Court will find violation of condition number 2 true. Court's understanding that you're asking for some time to report. Is that correct?
Yes, ma'am.
How much time is she asking for?
July the 30th, Judge.
All right. Norma, can we recall this back for August? I'm sorry. We cannot do July 30th. We can recall it back for July 28th.
That would be fine, Judge.
All right, Norma, can you recall this for July 28th?
Yes, ma'am.
All right, Ms. Robello, you'll need to be in the 187th District Court at 9 a.m. on July 28th. It's 300 De La Rosa, the fourth floor. Do you understand?
Yes, ma'am.
Okay, I will see you then.
Thank you.
All right, thank you.
Thank you,
All right,
Judge.
everyone, you're welcome. Everyone, I'm going to stop the live stream. I'll see everyone tomorrow at 9.